Got a question asking if you're trying to serve an unlawful detainer or an eviction complaint to a tenant and you can't find them, at the residence, or you don't know where they're at. What can you do? They haven't been seen in the house for over 20 days. Hi, my name is Rob Wells. I'm the Landlord on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, we get this question a lot, particularly from our clients, about, if we can't personally serve a tenant, at the home, or, we don't have another location for them. What can you do here? There's a special rule for unlawful detainer or eviction cases under Code of Civil Procedure, Section 415.45. We are allowed to post and certify mail a copy of the summons and complaint if we get a court order to do so. Now, let me explain how we have to do that. Now, generally speaking, the law prefers that everyone, get personally served your summons and complaint. Okay. Usually under the Code of Civil Procedure, I believe you have to try personal service at least 3 to 4 times. Okay. That's the bare minimum standard. Okay. Before you can rely on what we call substitute service. And substitute service, all that is if you go to the property where, the tenant is living, or your rental unit, right? And you've attempted personal service 3 to 4 times, and you find someone there that's competent, looks like that they're in charge, you can serve that summons and complaint on behalf of the tenant, and then you're supposed to mail a copy like in the mail. Okay. You can do that. Now, what happens if no one answers the door, right, after your 3-4 times? Well, depending on your superior court and your judge, you can go to you fill out an application. It basically says, hey, judge, I'm having problems serving the summons and complaint to the tenant. So pursuant to, CCP 415.45, I'm asking for a posting order. Okay. Our process server, they've been out here every day, at different times and hours, 4 different times type deal. And we can't get the tenants to the door. In fact, a good declaration of due diligence, that you have to show diligence, right? So you have to show your attempts, and you usually get a declaration from your process server, or if you're doing this, if you're having someone do it, you usually have to keep a log of your attempts, right? You want to show the judge, hey, we've been here at different times and hours. I've had some tenants that turn on the lights and stuff. You can hear people talking. They're just not answering the door. So what we just have to show is landlord has been diligent trying to personally serve the summons and complaint. And usually upon showing of that to a judge, the judge will grant this order to allow you to post a copy of the summons and complaint in a conspicuous spot on the property, usually the front door, and then you have to certify mail it to the tenants at the residential address. So that's how we solve that problem. Okay. There might be a possibility that the tenants might have abandoned the unit, and there's a different procedure for that. But usually I tell people, if you filed an unlawful detainer at this point, you might as well just go get a default judgment if you've come that far. But that varies on a case-by-case basis. You can't continue with an eviction if the property's been surrendered. So folks, if you're dealing with this situation and you need help with dealing with an eviction, right? Or just you don't want to go through this whole process by yourself, feel free to reach out. We might be able to help out. You can hit our profile down below, go to our website and book a free case review, and we'll see if we're a good fit or not. Okay. Put your comments, questions down below. I'll try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.